Loading now.
And folks, just remember to try to raise your hand, but if you have any issues on that, just wave to me or James, and we'll make sure we get you.
And we are live.
Good morning. Welcome to the public hearing of the General Law Committee. We have a number of bills on the agenda, and we might as well get right to it. Mr. Clerk, I think we have the Commissioner of the Department of Consumer Protection up first.
Yes, first is Michelle Siegel. Moving her as a panelist now. She should be coming in.
Yep, it's there. Okay. There you are, Commissioner. Hello, morning.
Morning. So Senator Maroney, Senator Witkos, Representative D'Agostino, Representative Retigliani, and honorable members of the General Law Committee. Michelle Siegel, Commissioner of Consumer Protection. I want to thank you all for raising House Bill 6100 and Senate Bill 693 and for the opportunity to offer testimony on those bills. These bills were requested by the department, and they do a lot of things. They're fairly robust bills, but a lot of it's aimed at streamlining our processes and then strengthening or clarifying a number of consumer protections throughout our statutes. Our details about what each section does and why we're requesting it is in my written testimony, which I won't reread here, but I'm happy to answer any questions you may have or clarify anything in that. So thank you again for having me.
I think we'll open it up to some questions. My general comments, and I think I've been sort of communicating with your staff on this. We've got a number of submissions today with respect to 6100 in particular. It's a big bill, and it just touches on a number of different things. And most of the speakers today have questions or concerns or have proposed revisions with that bill. And rather than us playing intermediary, what I'm hoping you can do is just ask your staff to reach out to those folks to read the testimonies. I know they're already doing that. Reach out to the particular constituencies that have submitted testimony and that we'll hear from today, and come back to us with a red line. Just as everybody's aware, we're losing our LCO attorney at the end of the month. This is a big bill. It would take us a while to walk through all those suggested revisions, some of which I think just from a visceral reaction seem like they're well-founded at least, but we want to make sure we get departmental input on them. So the easiest thing would just be to cut us out as the middleman right now, let you work with those different constituencies, propose to us any red line revisions, some of which I know you're already working on. And that'll certainly help us for purposes of being able to be comfortable advancing the bill. And I think I'll let the speakers later today touch on all those different pieces, but that would be a big help with the bill this large and encompassing.
Yeah, absolutely. And as you indicated, we've heard directly from a number of the groups, and we've been reading the testimony as it's been coming in. So we actually already probably have some substitute language that we've already agreed to with some groups, others that we're still working on and meeting with, but we're happy to be helpful and get changes that to the extent they work for us and for other impacted stakeholders.
Great, thank you. And I'd ask members to keep that in mind as well. You're going to see a number of comments today. And if you look at the testimony on 6100, and I think, and we've just heard from the commissioner, she's going to review those and get back to us. And I think we will obviously, as leadership on a bipartisan basis, make sure that you get that red line so you can see how those comments have been addressed before the bill is advanced. Senator Witkos, please.
Thank you, Mr. Chairman. My apologies, Commissioner, for getting on a little bit late. I guess I'll review the testimony in the red line, but I did have some conversations with some folks in the industry yesterday regarding the language of background checks and things. And my conversation, or actually my concern, was that the board using the FBI background check, when I believe that we could probably get the same data available to make sure the consumer is protected without using a full FBI background check. My understanding is from some of the industry folks that it takes up to 2 months to get that. And their type of industry is that they've got to try to place a caregiver with a patient or a consumer rather quickly. And so I have some thoughts about something I'd like to discuss offline with you, and maybe we can get to a place where everybody can be happy with the consumer being the most important aspect of that.
Okay, yeah, I appreciate hearing your thoughts on that, and we're aware of that concern. We do want to make that background check process more robust, make sure it's happening, and to address issues sometimes we see with identity theft. So we're comfortable that the correct person is being background checked. But we're aware of kind of the industry concerns, and we'll look forward to hearing your ideas as well.
Mr. Chairman, if I may, I'll just kind of spend a minute to tell the committee about what my thoughts were on this. So, my background, I was in law enforcement for 28 years. And so if I happened to have somebody that was in front of me, I had their driver's license or their ID, it's a simple matter of radioing in at the time to the dispatcher saying, check the national, it's called the NCIC computer. They would check that. That would have all of the states that are participants in that. And I think all but 7 of our states in our country are participants. Then there's also another database called the III, which is an interstate index, which has every state as a participant in that. And you can get somebody's background information, convictions, and current arrests within a matter of minutes. And so if we could come up with something where these folks could go to a local police department or state police barracks, we set the fee so it's not outrageous. And it could be done through appointments, just like they'd have to do with bus drivers going to get their background checks and things along those lines. I think that in that respect, it helps the industry, it protects the consumer, and we have the data that we're looking for to make sure that these folks are not hired if they've been charged within the past 5 years for those applicable crimes. But just a thought as we move through, and we can question some of the other folks that follow you.
Senator, just a question for you through the commissioner. I know it's still a lot, but you mentioned being able to go to the local police department. And a number of the testimonies that we saw with respect to this portion of the bill raised the concern of potential employees having to only go to a state police barracks, which, as we know, are only in certain locations and may be a little difficult to get to, especially if they're off the highway. Is what you're proposing, it sounds like, would allow for a more availability for potential workers to go get their background check done at a local PD. Is that correct?
Yeah, and how I envision it is that the department can come up with a form basically saying that, yes, this person has been convicted of or has been sentenced to these applicable crimes, or no, they have not, and it's signed off from somebody from either the chief of police or somebody within a local police department or a state police barracks. So that way we're not coming down on just the state police barracks, and folks, it makes it a little bit easier that for folks that don't have the ability for transportation, that they can just go to one of their local police departments. And that can be done coordinated through the local departments as to setting hours of when they can make, appointments to do that. So it's not an overburdensome ask of them.
Great, thank you. Representative Cheeseman, I think you had your hand up.
Yes, I did. Thank you, Mr. Chairman. Yeah, put it down so I wouldn't forget later. Thank you so much for being here today, Commissioner. And I just wanted to echo the good Chair D'Agostino's remarks. There has been a significant amount of testimony submitted on your bill. And I would encourage you, as you look at this, obviously with those red lines in mind, but particularly looking at some of the things to do with the health clubs that, as you know, have been one of the industries most severely affected by the pandemic and their limited business. So by all means, let's protect the consumers, but let's do it in a way that recognizes the issues that the health clubs have been facing. And I look forward to you working with the constituents and the committee to come up with something that's going to protect the consumers, but also recognize the business realities. Thank you. Thank you, Mr. Chair.
Thank you, Representative. Representative Ackert, please.
Thank you, Mr. Chairman. I missed your probably the two most important minutes of the beginning of the meeting when you probably mentioned that the commissioner's working on this bill. So I caught part of that. So what I will do is Reader's Digest questions here. I have 4 of them, but I'm going to give them all at once and essentially saying to the Commissioner Dagan for always the architects in the sections that deal with architects and their continuing education. I imagine I don't see anybody opposing that, so I believe that they're on board with your work on the lines 294 on with the architects. I take that with that section. It's pretty new, but I think it was something we looked at last year, if I'm not mistaken. And I was making sure that they were on board with that component of the legislation.
I'm not aware of any concerns from them on that. And a lot of this, it's been out there for over a year now because this was part of our agenda from last year. A lot of this, it's not really changing what industry needs to do. We're moving deadlines. What's often hard is continuing education, and we have it sort of tied to a whole bunch of our license types. But when continuing education is due at the same date for renewal, it becomes a challenge because we want to ask, have you completed your continuing education? But if you're renewing maybe 3 or 4 weeks before, some people don't wait till the very last moment to renew. So now you've renewed, you were planning to take continuing education before the deadline, but, maybe during that 2 or 3 week gap. So what's helpful is if we can just move continuing education, have it due 3 months before the renewal cycle. And that way, when somebody renews, we can ask them and they can really be held to honestly answer, have you completed your continuing education requirements? And we don't have that weird situation of them renewing with a plan to take it.
Yeah, as an instructor for continuing education, I do essentially, I know people that come in after the date because I think the license says, have you or do you intend to complete the continuing education? So I think that there's a concern by the providers to try to get everybody in the queue. I think that the individuals that are getting, I know especially electrical and HVAC, or HVAC plumbers. So I'll relate because I know that some of the providers have mentioned, maybe not be 3 months prior, maybe be closer to the date. And then the section, the contract section on lines 1375. The line saying who's working on the job. So if a contractor writes a contract with the owner, that contract is only valid if there's essentially that pretty big section that deals with the contracts. We did it in a home improvement contractor bill that's being worked on also. But it says who's working on the job. And I believe that's like, I give you an example. I sent a crew out that was scheduled on one job today. And because of the weather, we rearranged it and have different technicians going to that job now because of the weather. So it's kind of stringent. And then I've always struggled with the starting and finishing dates on some of these contracts, what people are looking for. But the problem with things like that is material orders, things like that. And I know that your office would review that if there was a concern and say, okay, circumstances outside of the contractors, we understand that, and then can forgive that. But it's kind of in writing in this paperwork. So a couple of areas that I have concerns with. I think some of the people in the field do, but we'll to see what comes of it from your work going forward.
Yeah, and we've met with industry. There was actually substitute language that we intended to have in this bill, but somehow didn't make it. So it'll be part of this red line that we'll be getting to everybody to address that very concern where sometimes you don't know at the time of the contract who the actual worker will be. So we have some language that I think we have agreement on with people, but we just need to get that substitute language into the bill.
Thank you.
Great. Thank you for those questions. I think you're getting a flavor, Commissioner, as we've kind of touched on different portions of the bill. I think it's a big bill, and I don't want to suggest that we're somehow faulting you and your staff for, we know we're always going to get industry comments and consumer comments on something that touches on so many areas, and we do appreciate everybody's kind of understaffed right now, so we do appreciate the willingness of you and your staff to be able to do that and turn that as best you can, and then we'll obviously take a look at it and see where we go from there. Thank you. Yeah. Thank you.
Thank you.
That's it. Thank you.
All right. Thank you all.
Thank you, Commissioner. I'm going to hand it off to our esteemed Senate co-chair, Senator Maroney, to politely grill the next two speakers.
Thank you, Representative D'Agostino. Next up is Senator Will Haskell. Okay, yeah, there he is in the room.
Good morning, everybody.
Good morning, Senator Haskell.
Senator Maroney, Representative D'Agostino, esteemed vice chairs and ranking members. This is my first time appearing before the General Law Committee, and it's an honor to be with you. I know you have a packed agenda today, so I just wanted to pop in and say a few words about a bill that's before you that I introduced, SB 152. Thank you so much for considering this legislation, which comes requested actually from a small business in my district. This concerns modernizing a small portion of Connecticut statute, specifically section 14-329, which requires the paper delivery of a ticket of a sort of ticket upon the receipt of home heating fuel. As is intuitively obvious, this takes time and resources, slowing down the productivity of these hardworking drivers. And it's especially become problematic during the pandemic, as this leads to needless exposure for both customers and for employees. Now, a crucial portion of this bill is that customers have the option to maintain the status quo if they prefer a paper ticket. It really just creates an opt-in system where customers who would prefer to have the truck idle in their driveway for less time to avoid a paper ticket being stuck on their door, they could actually move to an online system if they so prefer. And I know many members of this committee are wholehearted believers in modernizing our state statutes in a whole variety of areas. What this bill seeks to accomplish is admittedly incredibly modest, but I believe it'll be important from an environmental perspective to reduce idling and to reduce paper resources. It's important from a business perspective to help get these drivers on the road a little bit faster. And it's probably something that could have been done years ago, but as our state statutes catch up to technology, I think it's an important change. And I really want to thank the committee's leadership for taking a look at this bill. I want to thank DCP, which has been supportive throughout this process. And obviously their input is, I look forward to hearing their input on the bill, but we've had many productive conversations and they've been nothing but supportive along the way. So I'm happy to answer any questions that you have, but I just wanted to put in 2 cents as to why I believe this bill makes a small but important change.
Thank you very much, Senator Haskell, and thank you for bringing that concept to us. I believe Senator Whitcoast has a question for you.
Thank you, Mr. Chairman. Thank you, Senator Haskell, for bringing this forward. You know, it was interesting that we all didn't even realize that you had to do that until your bill came forward. I'll tell you, I filled out my co-sponsor form this morning to co-sponsor this bill. But just a quick question. Do you know what the potential receipt would look like if somebody were to get an electronic one? Would like form of an email, or did your guy explain to you, how easy it would be or how difficult it would be for a business to transition if a customer wants to opt in?
Absolutely. Good to see you, Senator Whitcoast, in another committee, another context. And thank you for supporting this bill. You'll be hearing later from the Connecticut Energy Marketers Association, which has been spearheading this bill. I've been in conversations with Galt, which is the company located in Westport in my district. They hope to start sending these online tickets if the bill should pass over email, just like we get a variety of other receipts. I don't know exactly what it would look like, but I would guess that it would closely parallel what they're currently putting on people's front door.
Excellent.
And by the way, Senator, since I know you come from a law enforcement background, I didn't bring it up in my testimony, but an interesting point that Galt raised is that some customers are actually frustrated when a paper ticket is left on their door if they're away on vacation, for example, because it signals to others that they're actually not home. So there's a public safety component to this bill that I never would have thought of if the company hadn't brought it to my attention.
Makes sense. Good bill, ought to pass. Thank you.
Thank you, Senator Whitcoast. I believe Representative Ackert, followed by Representative Cheeseman.
Thank you, Mr. Chairman. And we don't agree on a lot of things in legislation, but this one's is like I'm waiting to fill my co-sponsor form out on this one also. Makes sense, just like you just go, really? And I did, and you just made up a key. I just went away for a short vacation, really not a vacation in our world, but and I did get the COVID before and COVID test after, just so you know, just making sure I follow the state of Connecticut. But as to his point, what was hanging on my door, and I don't, it was, delivered, days, so you go back and you go, oh, I got my ticket, and I never thought of it. But this, just one quick clarification, this does not mandate a company from using this process, right?
No, not at all. And thank you, Representative Ackert, for that question. It's entirely optional, both for the company to utilize an electronic system, but also importantly, even if a company does decide to move to the electronic fuel delivery ticket system, it would still be opt-in for the customer. For whatever reason, maybe there are folks who are attached to that tradition of a paper ticket or who aren't as comfortable using an email system. So it's entirely opt-in for the company, and then it's entirely opt-in for the customer if they'd prefer to receive the ticket electronically. So glad we see eye to eye on this one, Representative, and appreciate your support.
Thank you, Mr. Chairman.
Thank you for your question, Representative Ackert. Representative Cheeseman.
Thank you, Senator Maroney. Good to see you, Senator Haskell. I think I'm going to be seeing you a bit later in higher ed if you as you zoom from meeting to meeting. Yes, I think Representative Ackert, you addressed that question for the customer. It is an opt-in. It is not default that you have to opt out, because as we've learned during the pandemic, there are still significant numbers of people for whom living and working in the electronic world is not as easy. But yes, it seems crazy that we haven't addressed this before. And I can tell you, as the owner of 2 large dogs who are very friendly but very vocal, I'm sure the man will be very happy not to come to my front door to be greeted by 165 pounds of Chesapeake Bay Retriever. So thank you so much. And I think, like Senator Whitcoast, I better sign on to co-sponsor this one because it sounds like a goodie. So thank you. Thank you, Senator Maroney. Thank you, Senator Haskell.
Thank you, Representative.
Thank you, Representative Cheeseman. Seeing no other questions, Senator Haskell, thank you very much for bringing this concept before us and coming to testify. And we invite you to come back to the General Law Committee more often for these kumbaya moments. So.
This went well, man. I'll be back. Have a great day, everybody. Stay healthy.
You. Have a nice day. Next, Senator Berthel.
All right, they're all coming in now.
Okay.
Good morning.
Good morning, Senator Berthel.
So good morning to the co-chairs Maroney and D'Agostino, ranking members Whitcoast and Rutigliano, and distinguished members of the General Law Committee. I guess I could have had Senator Haskell kind of introduce my bill as well. This is a very simple piece of legislation that I think will allow for some good changes to take place. I'm here to testify before you on Senate Bill 186, which I introduced on behalf of a constituent of mine who is going to testify as well this morning. This is an act allowing persons 16 years of age or older to operate rides at amusement parks. Essentially, the bill, and my guest will speak to with much more intelligence and knowledge on this subject matter than I have. I do not operate an amusement park or support them more than just being a good legislator for my constituent. But the crux of this is that this is done in other states, and it will essentially expand employment opportunities for youth. Mr. Francis will speak, who is the 3rd generation co-owner of Quasi Amusement Park in Middlebury. If you've never been down to Middlebury, it's right on Lake Quaspog. It's a great old-fashioned amusement park, been there for many, many years. And Quasi is very often the first employer for many youth. They employ about more than 200 young people seasonally each year. I think this bill will give them an opportunity to expand employment opportunities for young people. And as the experts can speak to in a moment, it's been done successfully in other states very safely, and protocols and training behind it. So I appreciate the indulgence of the committee to allow my guests to speak during my time this morning. I know you do have a busy agenda. But with that, before we have my guest speak, I'm happy to answer any questions that the committee members may have of me before those guests appear before you. Thank you, Mr. Chairman.
Thank you, Senator Berthel. Senator Kissel?
Yes, thank you, Mr. Chairman. My question is, what's the current age limit? Is it 18?
Senator, thank you for the question. Yes, my understanding, and again, my guest can speak more intelligently to that, but my understanding is the statute currently restricts the minimum age to 18 for operating an amusement park ride as defined by the law.
And my second follow-up question, and it's the last one, is would the 16-year-olds who can drive a car, right? Would they get any kind of training as far as safety and things like that? I've been to a lot of carnivals and things like that. Some of these rides look a little dangerous. I have a 17-year-old. I don't know if I want him pulling the levers on the Ferris wheel, but you know.
Sure, Senator, thank you again for the question. In conversations with Mr. Francis earlier this week, I actually asked him the same questions. And in addition to proper training, which again, one of the guests that's following me will speak to the training protocols, Connecticut already has in place some very stringent safety protocols that are required of the ride itself. Things like a so-called, I think I'm using the wrong terminology, but it's like a dead man switch, that if the operator gets distracted, someone walks by, a friend calls their name, if they take their hands off of the controls, the ride comes to a controlled but safe stop. So there's a lot of things that were already in place, exactly the same concerns I had. And certainly we do license 16-year-olds to drive 2-ton cars down the highway. And this is something that I think is actually a more controlled environment. And but again, the experts are on the call with us this morning and can speak, I think, with more eloquence than I can regarding that. So thank you, Senator.
Well, thank you, Senator, as well. And as the father of a 17-year-old who's put in applications all over the north central Connecticut trying to get a job, and there's just not a lot of stuff out there, and they just want to sort of stay back. I think this is a great opportunity. I think, as someone who started work at 14 myself, the faster you start to learn to work, the better off your life can be.
Yeah, I agree. Thank you, sir.
Thank you.
Thank you, Senator Kissel. Are there any other questions? Representative Vitigliano.
Good morning, Senator. Can you hear me okay?
I can.
Okay, I'm having some Zoom issues this morning. I'm on my third reboot, so I didn't know if people can hear me or not. My question really would be for your guest, if that's okay. Are they ready to answer questions?
Yeah, I think they're all on. All three of them are on as me.
Okay, so if they could unmute, really, I really only have one question, and that is, would this, by us passing this bill, this would not supersede any issues you would have with your insurance. If your insurance is okay with a 16-year-old doing it, then the law would not, or not okay with it for that matter. The law wouldn't change that at all, would it, sir, to you?
I think, Eric Beard, this probably is a better question for you because you're more global. But as far as our insurance company and our operation, I don't see that being a correlation. Because within our industry, and again, Eric Beard will testify more on that issue, there really isn't any data that there's a correlation between the safe operation of a 16 and 17-year-old ride or an 18-year-older. So
but one would presume that if there was an issue, your insurance company would either say no or raise your rates to a point where you couldn't afford it, correct?
Correct. And there's over 41 other states that allow 16 and 17-year-olds to operate rides. We're not pioneers in this bill.
Thank you. That's all I had, Mr. Chairman. Thank you very much.
Thank you, Representative Vitigliano. Senator Berthel, were one of your constituents going to
Yeah,
speak?
so I'm not sure who wanted to go first, but all three are on again. Mr. Francis, would you like to proceed? And Mr. Chairman, with your indulgence, would that be okay for Mr. Francis to proceed?
Yeah, Mr. Francis can proceed. Again, we were supposed to be a 3-minute total. We went to questions before, so
They'll be quick and they'll be brief and be gone.
Okay, thank you.
Thank you,
We
Senator.
do have just a large agenda today. That's all. So thank you.
And again, committee, I greatly appreciate you giving us the time today to speak on behalf of the bill that Senator Berthel is proposing on our behalf. And again, we are going to be brief because we do understand the length of time that you have today, and we greatly respect that. So as a group, we've gotten together, we've really broken it out into segments that we feel are important to elaborate on. And I'm here basically just to introduce the experts, let's say, that may be able to answer questions more specifically to the technical aspects of it. But before I do pass this on to my esteemed colleagues, I do want to make one quick statement that, representing the amusement parks in Connecticut, which consists of Lake Compounds, Ocean Beach Parks, Sunny's Place, and a few others, and Quasi Amusement Park. I think we have well over 500 years of operation in the state, of continuous operation in the state. And customer service and safety are the two most paramount issues that keep us sustained throughout the years. So compromising on both of those is not even a question. So when I sat with Eric and Senator Berthel and requested him submit this bill, it was after great thought and looking what has been done around the country and talking to my parks within the state and the New England Association and the IAAP International Association. We felt very comfortable being able to submit this and still maintain the level that we think our guests and our employees expect. So on that note, I'd like to pass the rest of the time on to Eric Beard, who will be representing the International Ride Training Association, and then he'll pass it on to Ed from the New England Association, who will be representing the industry. And so I think from those perspectives, we think we can get a pretty, hopefully we can educate the committee on how important this topic is and the safety issues are how important they are to us as well. So on that note, and in respect to time, I'm going to pass the torch to my esteemed colleague, Eric Beard from International Ride Trade.
Good morning, members of the General Law Committee. My name is Eric Beard. I'm managing member and general counsel of International Ride Training. We are a ride operations safety consulting firm. I live in Avon. I've already submitted written testimony in support of this bill, so I'm happy to answer any questions that you may have in that regard. I did want to address Representative Ritigliano's question, if I may, about insurance rates, because I did inquire of some operators that I work with in Michigan and Minnesota, both of whom lowered the operating age from 18 to 16 between the 2019 and 2020 operating seasons, both of which commented to me that their insurance companies had absolutely no issue with it, that it was a complete non-issue. They never even raised the question about it when the bill was being passed. So I think that also speaks to the risk profile that's involved here in lowering these ages. With that, I will take any other questions, only to echo what George has said about guest safety. It is our primary and most important job function. And I can also speak very quickly to something Senator Kissel raised earlier as to the operation of these rides. I can assure you that any 16 and 17-year-old who's driving a vehicle has far more control over the operation of that vehicle than your typical ride operator does. Modern rides, and by modern, I mean anything manufactured in the last 30 years, really, are very automated. Speed is electronically controlled. Ride operators have important duties, but they are not able typically to change speed or to dispatch a ride without, restraints in the proper position. They often have to be standing in particular places and holding a dead man switch so that they can operate safely. So really, the operation of a ride is in reality far safer than the operation of an automobile. And yet, as Senator Kissel pointed out, we allow 16-year-olds to operate automobiles on our highways every day. So with that, I don't want to take any more of the committee's time, but I'm happy to take any questions.
And I think before we go to questions, if your colleague could speak, and then we'll just
Certainly
do the questions. I do see there are three people who have questions. So
certainly, Ed Hodgson is with us from the New England Association of Amusement Parks and Attractions. Ed, do you want to go ahead?
Sure. Thank you, members of the committee. I will be brief. Just echoing some of the points that have already been brought up. There is no research or data that suggests that amusement rides are safer simply because they're operated by 18-year-olds, and conversely that they are less safe when they're operated by 16-year-olds. So we already know that there is no data to support that. And then any ride operator that does, or anyone who is hired to be a ride operator, regardless of age, is going to receive the exact same training. There isn't going to be any differentiation between the training that is done for a 16-year-old to an 18-year-old on the same amusement device. Again, as Eric Beard and George Francis pointed out, there are numerous safety features that are in there, dead man switches, other sensors and things like that do make a ride operation very, very safe. So I would also entertain any questions.
Great. Before we go to questions, just one quick question. What are the ages for the other states in New England? Are the other states 18, or which states are 16? Ed, if you could answer that.
Sure. I know that where I'm based in Maine, we are at 16 years old. New Hampshire has 15-year-olds for some rides, 16 for most others, and up to 18. Eric Beard, the other states would be Rhode Island is at 16, if I'm not mistaken.
Vermont and Massachusetts are both at 18, and Rhode Island has a mixture of 16 and 18 years old, depending upon the type of ride. But primarily, in practical effect, it works out to an 18-year-old requirement in Rhode Island. But there are a small group of rides that can be operated by 16-year-olds.
Great. Thank you very much. I'm going to go in the order that I saw the hands come up. So Representative Winkler, then Senator Kissel, then Senator Witkos.
Thank you. While I respect the fact that there's limited research on 16 versus 18-year-olds, there certainly is, research concerning brain development, brains not being fully developed at 25, impulse control, in the teen years, et cetera. I looked into some of the other states, and most of them seem to have switched to 16 when they experienced a labor shortage and needed to go lower in age in order to get people to run the rides. We don't seem to have a labor shortage in Connecticut right now. Are you having trouble hiring people to operate these rides?
I guess I'll take that question. Even with the unemployment rate where it's at today, we do seem to, I guess it's a twofold answer. So at the end of the day, we're educators. We spend a lot of time on training young adults to enter the workforce and give them an opportunity to start off. There is a significant labor shortage in Connecticut. And again, be it COVID, be it people looking for full-time year-round positions. I think most summer establishments like ourselves do struggle to obtain labor force of 18 and over. So, as far as the selfish part of the bill, it would be extremely helpful for our industry to have that 16 and 17-year-old to be employed. And and we do hire a substantial amount as it is already. And, again, our training, it doesn't distinguish between 16, 17, or 18. We give everybody the same amount of training. There are some operations that we allow 16 and 17-year-olds to be attendants on rides, which means they're assisting in the loading and unloading, and so their knowledge and their training is significant. So they do have the proper knowledge.
Thank you, Mr. Chair.
Thank you, Representative Winkler. Senator Kissel.
Yeah, thank you, Mr. Chair. Just a very quick question. I think it's George had mentioned Sonny's Place, and I believe I have a Sonny's Place in my district in the town of Summers. Is that what he was referring to?
Yes.
And you consider that an amusement park? It has grown vastly.
Yes, they have amusement devices where it would behoove them. This bill would help them as well.
Okay, thank you. Just a parochial question.
Thank you, Senator Kissel. Senator Whitcomb.
Thank you, Mr. Chairman, and thank you to Senator Berthel for bringing the bill forward. I do have a concern, and I want you guys to speak to it if you could. While I understand the safety around built in for the amusement park rides, I'm also very familiar with these carnival rides where they come in on a Wednesday and they're out of town on a Sunday. And, you know, I've been involved in my former life in law enforcement and working on the fire department where the fire marshal goes and inspects these rides. And oftentimes I've seen rides put out of commission because of whatever the reason is. And so I have some concern that we would allow 16-year-olds to be operating carnival rides that pop in for a weekend and pop out, where they don't have the history of the maintenance in the state and the long-time operators that are doing the training. Would you be, if we were to draft some language that would prohibit this for temporary facilities, would you guys be opposed to that? And if so, why?
I can take that question. The answer is no, we wouldn't be opposed to that because in effect, this bill really wouldn't affect the carnival operation anyway. And the reason for that is because carnival operators tend to want an employee that can kind of do it all. They want somebody that can travel with them, that can set up and tear down the ride and operate it. Under the federal labor laws, 16-year-olds are not allowed to set up rides, maintain them, or tear them down. So most carnivals don't have really any interest in hiring a 16-year-old because they don't want somebody that can only do operation and then do nothing else. They want them to be able to stick with them from town to town and help maintain the ride. So in effect, the carnivals wouldn't be affected by this at all because they don't even want to hire 16-year-olds. So if we wanted to put that in the bill, you wouldn't get any pushback from us.
All right, because for me, for a comfort level, I like to have something in there because who's to say that somebody doesn't come down with a bug as the carnival's in town and they say, hey, local, you know, as they're getting inspected, do you have any 16-year-olds that can run this ride for 3 days? Mm-hmm. I just don't feel comfortable with that. But the underlying bill, I absolutely do and support it. But I just wanted to make sure that you guys would not be adverse to having some carve out put in there or some protections put in. Thank you. Thank you, Mr. Chairman.
Thank you, Senator Whitcomb. Thank you for bringing that concern. Are there any other questions?
Mr. Chairman, thank you again for the indulgence of the committee for a little extra time this morning. And I appreciate the comments and the questions to my guests. Thank you to my guests for testifying as well. And I hope you have a quick and easy rest of your public hearing this morning. Thank you.
Thank you, Senator Berthel, and thank you for bringing this issue to us. I think my co-chair, Representative D'Agostino, is going to take over for now.
I will. Thank you, Senator, for shepherding us through your two Senate colleagues in those two very. Mr. Clerk, who's next, please?
So now we can begin public individuals. So up next is Greta Wagner. Promoting her now, and she should be coming up.
Hi, sorry.
Hi, Greta, you're on.
Okay, terrific. Thank you so much. Senator Maroney, Representative D'Agostino, Senator Whitcomb, Representative Rettigliano, and members of the General Law Committee. My name is Greta Wagner, and in addition to operating a very large fitness and sports club in Connecticut, I'm also on the board of directors of IHRSA, the International Health and Racquet Sports Club Association, and our mission is to grow and protect and promote the health and fitness industry. On behalf of the Connecticut Fitness Alliance, I thank you for the opportunity to provide comments concerning Section 1 and 2 of SB 693, an act concerning changes to the consumer protection statutes. I'm here to express our concerns about the financial and administrative burdens that this legislation could pose to health clubs, including those smaller individual health club businesses. There are approximately 700 fitness clubs in the state that employ and serve millions of customers, and even more when you include those small single studio operators. Our industry has been hit incredibly hard, like everybody else, but really hard by the pandemic. At a time when our clubs should have been deemed essential businesses, we were forced to close our doors. This was detrimental to many of our members. their mental and physical well-being. At the time, our industry froze memberships, and we really acted responsibly, working with the governor, working with, all of our sector rules. We have slowly and partially reopened our clubs responsibly and safely, and our clubs have made substantial investments in our buildings and our business practices, contactless plumbing, temperature check equipment, signage, cleaning equipment, PPE, additional training for our staff, additional programming, and for social distancing, to really make sure our staff and our customers are safe. In fact, as members have returned to our centers, many of them tell us how important their club is to them, and their workouts have helped them deal with chronic health conditions and really have made a difference in dealing with the negative impact of the pandemic. The Connecticut Fitness Alliance supports Section 1 of the bill, which brings the contract cancellation provisions up to date with expanding the method of notification to include electronic mail. We understand that this tracks with current day business, contracts, and it's important that both the consumer and the businesses have a written documentation for their records. So Section 2 of SB number 693 implements a notification requirement, which would pose an administrative and financial challenge to many health clubs. Processing, numerous renewal notifications, especially for the clubs that are smaller and have less resources. They might not have the technology or the infrastructure to help with such a requirement and won't be able to follow it. Since not all health clubs contracts renew on the same day, we enroll members every day, many members every day, starting on the first of the month.
Wagner, you got the 3-minute marker. If we can start if we can start wrapping up, please.
Okay, so a lot of those contracts roll over already into month to month, and it would be a significant burden. So it would, be very time consuming and add additional and unnecessary resources and financial burden. So our contracts already have strict regulations, and our operators are transparent in highlighting those options and communicating the benefits and restrictions and the commitment level of time. They can cancel any time after their initial commitment if they so choose in a year contract. They can cancel anytime after the 30 days notice. And it's common practice and convenient for all. The consumers are accustomed to living in a subscription and contactless payment world. So it's a huge burden for us. So I'm asking if you could take my comments to heart when you're reviewing the bill.
I'm sure we have some questions for you too.
Okay.
Maybe. Or maybe not. I thought Representative Cheeseman might.
Of course, you read my mind, good Chair D'Agostino. Thank you for coming here today. And I just want you to, you've laid out what the administrative burdens would be, but could you just share with us what some of your members have experienced during the pandemic with that forced shutdown? And I have a vested interest in this, not because I run a fitness center, but because I run a children's museum with a membership structure. And again, we were forced to shut down, and how we've dealt with that. So if you can just, share both the economic impact and, in effect, decimation for many of your industry, and how this has played out, how you've responded with the pandemic to your members to ensure them that they will get value. So if you could just share some of that with us, please.
Immediately during the pandemic, we notified and communicated with all of our members, stopped payments, obviously, credited the time that they had already prepaid for the month because our shutdown was mid-month, and reimbursed or credited when they returned. So, the key to everything is communication, and we do that regularly. When we were able to reopen in June, so many people came back, obviously nervous, but they came back to us, and we had so much additional expenses for training, for signage, for we had to bring people in to move equipment, and hand out masks and cleaning, their own individual cleaning solutions. I added staff to clean the clubs. So we're already under such great burden right now to have something else in the mix that would require more administrative responsibilities and additional expenses is just right now is, misplaced a little bit for what we're dealing with.
Okay, thank you. And I think
the question.
Sure, yes, you did. And I think unless you're actually dealing with this on a day-to-day basis, and we want to protect the consumer, as does the commission.
Absolutely.
But having lived this myself with the museum, investing tens of thousands of dollars into additional cleaning, additional improvements in HVAC, totally operating, changing the way you operate to make people safe and keep people safe, I'm very aware of not wanting to put additional burdens on business owners like you and your members who are struggling to survive. And I do think, particularly with the gyms and the fitness centers, for so many people, when we look at the mental health benefits of regular exercise, and there, I work a lot with the mental health community, the suicide prevention community. For many people, this is how they maintain a normal life. That workout, that ability to do those things, keep them centered, keep them in a good place, not only physically, but mentally. And I appreciate your testimony, and I know the good chair doesn't want me to rabbit on anymore, but I think it's important when we consider these things, yes, protect the consumer, but also be aware of what we are doing, an additional burden we may be placing on business owners, primarily small and medium-sized business owners, because we're not talking the giant chains here. And we should be cognizant of the fact that even little things that we do can add just one more piece to their, and because you don't have huge departments who are going to produce this correspondence, it's going to be the owner or someone like that. So thank you. I've made my point. Thank you for coming today. And I look forward to you and the industry working with the commissioner and this committee to come up with a good solution. Thank you very much, Mr. Chair.
Thank you, Representative. Senator Kissel.
Yeah, hi, good morning. I know that Chairman D'Agostino, and I'm sure that Chairman Maroney is on the same page, doesn't want us to be caught in the middle of this. Have you guys been in discussions with the Department of Consumer Protection to try to iron out some of these problems?
Yes, we are working through our representatives and lobbyists to work our way through the bill. It's a little, what's being asked is a bit redundant because at the time of signing the agreements, they have many choices. They don't have to commit to a 12-month. And then when they roll over to the month-to-month after that, they can cancel at any time. So to have to give notice 45 or 60 days beforehand, when we have them initial, that they understand that it's an auto renew. We live in a subscription world. It is an auto renew, for many, many businesses, Netflix, our phone bills, our newspapers. So I hope that, yes, we're trying to make strides and communicate why we think that this is not necessary. We want our consumers to be educated. They are very educated as far as, frequenting health clubs, and fitness is important to them and health is important to them as to us. So, we're very transparent. So it's unnecessary in my opinion.
Well, I appreciate that, but I also appreciate the chairman's observation and the ranking member's observations that we don't want to get in the middle of this. So you guys got to really work hard with the commissioner and the department to try to redline that bill as much as humanly possible. And then we'll see it at the end of the day. But I just think that that's, given Zoom and, efficiency issues in the COVID, I just think, you got to fight your own fight a little bit before we step in. There's complicated things that only our committee can do, but there's other things that you guys can do. And she seemed pretty accommodating when she came to speak. So I'm hoping that that follows through. And this is
Great,
sort of
so do
like
I.
a little homily to her as well. I mean, I'm sure if she herself is not still watching this hearing, someone in her department probably is.
Mhm.
I just wanted to say that.
Thank you.
I'm sure that they are. Yeah, there's no more questions, so I'll let you go with just one final thought. This is also more for the committee. You know, this doesn't. I appreciate everything you said, and we always want to try to find a balance between the consumer needs and the business needs. Hopefully, they don't diverge too much. You know, this isn't coming out of the blue. You know, DCP gets a number of complaints about cancellations every year. This is where this is coming from. And I will note for the committee that we also had members, I know I had House members proposing bills or asking me about bills to just bar completely the automatic renewal. And I told them all that DCP had a bill that was dealing with this. So this isn't just something from DCP. I'm hearing it from my members. And it is a perennial complaint about your industry. So I do think this committee is probably going to do something on it, but you should work with DCP, as Senator Kissel mentioned, and try to find common ground.
If I could just make one more comment to that, with the hundreds and hundreds of thousands of members that frequent our clubs throughout Connecticut and nationally, the amount of complaints that come in comparison to the number of members that we serve. I mean, I can only, yes, during the pandemic when we had nobody in our offices, there was probably 1 or 2 complaints that came in that we missed because we didn't have the opportunity. But, there's less than a handful that I have seen in each club, situation when they're servicing thousands and thousands of people. So just to put it in perspective. Thank you. I appreciate it.
Thank you, Greta. And we'll move on to the next speaker. Thank you, Ms. Wagner.
Thank you.
Okay, so next is Raphael Podolski.
Oh, Rafi.
Coming on now.
He's someone Senator Kissel knows.
Oh yeah, he's perennial at Judiciary.
I'm sorry, can people hear me? I'm having a little difficulty on my computer.
We can hear you.
Can't see you, but we can hear you.
Thank you very much.
And I can see you. There you go.
I realize this is a new experience for a lot of people. Some of us, I think, are quicker to figure out how to do it than others. I'm in the slower category here. My name is Raphael Podolski. I'm a lawyer with Connecticut Legal Services. We're part of the legal aid programs. I'm here to speak very briefly about sections 36 and 37 of House Bill 6100. In this context, we represent people who live in mobile home parks, and those 2 sections make some small changes in the mobile home park statute. The Department of Consumer Protection regulates mobile home parks. This is very important because people in mobile home parks typically own their own mobile homes, but they rent the lots. And if you lose your right to rent the lot, you run the risk of losing the entire value of your home. The department has those 2 sections are there from the department's end, I think, to help them with from the enforcement perspective. I've submitted written testimony. There are some changes we would ask you to make. We've been in touch with the department about these, and we're talking to them about it. So I would expect that we will follow up in the way the committee has suggested. But just so you know what they are, one is it's important to us that there be clarification that there will continue to be annual inspections of the park. And there's some language in section 36 that raises some question about that. I don't think it's intentional. The second thing is that in terms of the department being able to act in emergency situations where people's health or safety is immediately at risk in the park, we've suggested some brief additional language in section 37. And finally, there's a fairly subtle difference between the use of the terms inspection in the park and investigations done by the department. And we've asked that we're suggesting that in several places in Section 37, both of those categories be referenced. We would ask you to take a look at those things. And as I said, we are talking to the department directly, and we're doing our best to see if we could work something out with them. But our real concern is the importance of maintaining strong protections for park residents, which protects their right to live in the park. And this goes back through many, many years. Those of you who've been around a while know that some of the park protection laws go back into the 1970s, and it's quite important for a lot of people. So thank you very much for the opportunity to speak, and I'm happy to answer any questions for you that I can. Thank you.
Let me see. I do not see any for you, Mr. Podolski. So thank you for your testimony, and please continue to work with the department on your concerns.
Thank you.
Thank you. Mr. Clerk.
Okay, next is Mark Mcgoldrick. You should be in now.
There you are. I can see you. I can't hear you. There you go. You're on.
Hear me?
I can see you.
All right. Thank you. Good morning, Chairman Maroney and D'Agostino, vice chairs and ranking members, Senator Witkos and Representative Ritigliano, and other members of the General Law Committee. My name is Mark Mcgoldrick. I own and operate 6 offices around the state of Connecticut under the Comfort Keepers brand. I have offices in Bloomfield, Milford, Shelton, Southbury, West Hartford, and Westport, Connecticut. I am also the current chairman of the Connecticut chapter of the Home Care Association of America. I would like to thank the committee for its opening comments, suggesting to the commissioner that the department work closely with stakeholders on compromise language around House Bill 6100. I would also add that we are in discussions with Commissioner Siegel and her department around modifications to Section 24 and 26, and I'm hopeful that with Senator Witkos's leadership, we can come to some compromise language. So I'm not going to go into a ton of detail today because I posted very detailed testimony this morning, which you guys can read, and it kind of very clearly outlines all the problems with Section 24 and 26 of House Bill 6100. I would like to state that, protection of seniors is the #1 priority of HCAOA and really home care agencies in the state. We support comprehensive background checks as an effective tool for protecting seniors. And I believe the solution here is really around providing more structure and definition around the definition of what a comprehensive background check is, okay? Section 20-675 paragraph 5, or 670 paragraph 5 is where the current definition resides. And I think there's modifications we can make to that definition that will satisfy everyone. And there are changes like, maybe coming up with an approved vendor list of third-party background check companies, putting more definition around the exact type of searches you want done. You want a state search done. You want a national search done. Do you want a social security trace done, which is another form of positive IDing the person so you don't have the type of misrepresentation and fraud that Senator Siegel mentioned in her comments. So I think we can drill down on some of these things. The other ideas, and this is what Senator Witkos is talking about, but identifying the specific databases from law enforcement that people are using, right? That's another way to put clarity around this definition. So there's a lot of easy fixes here. I would also like to add that we don't need to reinvent the wheel here. There's a huge multi-billion-dollar industry that does third-party background checks every day. for corporate America, right? And I use a company called Checker, okay? And it's a it's a global company. I can do a background check, which does, criminal, state, national, social security trace, driver's record check, 7 years. I get it in 2 or 3 hours. It costs me $30. And it's as good or better than any FBI background check. And it's done quickly, cost effectively, expeditiously. These searches and these companies exist. So in the age of technology, there's kind of no reason to kind of go back to the Stone Age, which is, making people go and fingerprint themselves.
Excuse me, Mr. Mcgoldrick, we are at the 3-minute marker. If we could start wrapping up, please.
Sure. All right, the last comment I want to make is around section 26, dementia care. This is business names and advertising. We've asked for an exclusion to say that HCAs can do dementia care. The issue here is that there is no medical treatment for dementia care. Dementia care is provided today by HCAs. It's really the only treatment is managing behaviors and communicating with dementia patients that is done by HCAs. And if we don't have the ability to advertise on our website that we treat dementia patients, consumers in the state of Connecticut will have nowhere to go to find any kind of care for their loved ones. All right, I'm done. Thank you.
Thank you. Yeah, we know you're in conversations with the department, and we do encourage you to continue those conversations. We look forward to the red line language. Senator Whitcomb.
Thank you, Mr. Chairman, and thank you, Mark, for testifying this morning. What did you find was the difficulty that the section would have had if it said something about false advertisement and using the example of Alzheimer's or Alzheimer's care or something like that? Could you expand a little bit on that for me?
Sure. So the current position of the department is that we cannot advertise that we provide care to patients with any medical condition. Okay, so they're saying that Alzheimer's is a disease and therefore it can only be treated or cared for by medical professionals. Okay, but the fact of the matter is, Senator, there is no medical treatment. The tragedy of Alzheimer's disease is there is no treatment. There's no medical treatment for Alzheimer's, right? The way you take care of a dementia patient is through knowing how to communicate with them, modifying behaviors, keeping them safe. And that service is really only performed in the state of Connecticut by HCAs. You call up your visiting nurse association, they won't do it because they don't do it. It's not a Medicare reimbursed thing. They don't do it. They don't have expertise in it or experience. And so what they're saying is I can't put up on my website the fact that I do advertise, that I take care of people with Alzheimer's disease because it's a medical condition and I don't provide medical services. And here's the challenge. 70% of home care is arranged for by the eldest daughter in a family. So what happens in many circumstances is that daughter lives out of state. So I have a woman who lives in California who's trying to get care for her mom in Milford, and she has to go on the internet to do that and do a Google search. And if we're prohibited from having anything mentioning Alzheimer's on our website, they're not going to find any results in their search.
I understand the predicament. Did the department, without cutting hairs, I guess using the word of Alzheimer's, did they say anything about memory lapse or memory care? Would that be prohibited under what they're trying to accomplish?
We've tried to modify the definition or the term, and every time they've said no.
Okay, right. Thank you. We'll have to ponder that a little bit. Thank you, Mr. Chairman.
Thank you, Senator. I think we hear the concerns here, and we'll, again, I know you're talking to the department. I don't see any more questions for you, so thank you for your testimony.
Thank you.
Mr. Clerk.
Okay, up next is Leah Cantor. She's in now.
Yeah, I see. Ms. Cantor, can you hear us? Get on mute.
There you are. Hi.
There you go. You're on.
Okay. Good morning, distinguished chairs and members of the committee. My name is Leah Cantor from Bloomfield. Thank you for the chance to speak today in support of Raised Bill 6100. I'd like to share my thoughts and my proposals as to how it can be improved. So my mom hired a Connecticut home companion agency to provide 24/7 live-in care for my dad in their Bloomfield home. He had dementia and required 24/7 supervision as he was a fall risk. He could, however, get up from a chair by himself, but he couldn't stand alone. 2 years later, my mom died and the caregiver stayed on. One day, I made a surprise visit to my dad and found him home alone. This is called neglect. It's also called elder abuse, according to DSS. I couldn't help but wonder how many other times she left him alone. In the 9-month period after my mom died, the agency didn't provide a single unannounced supervisory visit to my dad's home to check up on the caregiver. Other than one daily required call to the agency's system, the agency had no idea if the caregiver was at work. Though timesheets state that they require client signatures, she submitted them unsigned and was paid. After the caregiver was removed from my dad's assignment, the police had reason to believe that the caregiver's identity was questionable as they could find no trace of her. I was stunned to learn that I might not have known her true identity after 2.5 years. I discovered a legal case brought against the same agency where the client representative stated on record that he learned that his caregiver had assumed someone else's identity to gain employment with the same agency. After 2 years of her employment, he learned that she was not who the agency had introduced her as. A legislative aide told me she had an elderly friend who had a daily caregiver who would often leave during the afternoon, only to return 15 minutes before the end of her day to clock out. We need to do better. I am in full support of maximum background checks, including fingerprints, and I'll explain why. First, healthcare workers in nursing homes are all fingerprinted. Why should my dad be provided with caregivers that are any less vetted because he chose to be cared for at home? He deserves the same safety as those in nursing homes, if not more so. In fact, because there's no regulation in place to monitor HCA caregivers, that caregiver should be fully vetted to the maximum potential. Second, caregivers can get to any client in the state of Connecticut, as well as to agencies for interviews. They should be able to get to one of the 13 or 14 police barracks. Otherwise, agencies can take prospective employees in a van all at once. Priorities should be in the best interest of the clients, not the employees. Third, if it's your parent, I would think you would want to know everything about the caregiver, not just the basic background check. That is beneficial to the agency to prevent liability and to the client who can rest assured that their loved one is being taken care of by someone who is not a criminal. Fourth, the cost of fingerprinting is a lot less than a legal suit and attorney's fees. Choosing profits over people is no way to run an agency that is in the service industry of keeping clients as safe as possible. What dollar amount are people comfortable with?
If we can start wrapping up, please.
Oh, sure. Fifth, caregivers move from agency to agency and often have many IDs. Fingerprinting is the only sure way for police to identify criminals. Home Depot requires fingerprints and urine tests to sell hammers and nails. And agencies don't want to pay for comprehensive background checks to have someone living in a client's home. Bill 6100 needs to go further and regulate the oversight of both the DCP and HCAs. The DCP does not have the resources or the authority to regulate the quality of services provided by HCAs. So I ask, who is? Furthermore, I don't see any policies or regulations for issuing penalties for regulation violations. HCAs with repeat violations continue to have their registrations renewed. A post-audit a DCP post-audit letter issued in 2019 stated both the agency and its employees have embarked in a pattern of behavior designed to mislead, deceive, and defraud the public, as well as the commissioner. Just 1 month prior to that statement, the DCP reviewed the registration.
I do appreciate your testimony, Ms. Cantor, and we've got a full agenda today. So thank you for spending some time with us, and I encourage you to submit your full written statement to us so we've got it.
Yeah.
Thank you. I don't see any questions for you, and we can move on to the next speaker, Mr. Clerk.
Thank you.
Okay, up next is John Cholanski.
Good morning. Am I have my?
You are on.
Okay, and my video is on now. Great, thank you. Distinguished chairs and members of the committee, my name is John Cholanski, and I'm Managing Director of Elder's Choice, which is a homemaker companion agency that is classified as a registry. And I'm also an employer fee paid employment agency registered with the Department of Labor. I'm also the former president of the Connecticut Association of Home Care Registries. Registries is a separate animal in the statutes. And for all intent and purposes, my business is as an employment agency is to place a private duty caregiver as a home care provider in a home or a residence in the state of Connecticut. You have my comments and my written comments. I'm really not going to go into them in much detail. I really respect the DCP and the commissioner a great deal. I have appeared before multiple committees for the last 8 or 10 years discussing the challenges of home care. And I feel sorry for Leah Cantor, the prior speaker. The fact of the matter is, first of all, we need background checks the way that background checks have been defined here in the statutes as proposed. The problem here that the implementation is all but discriminatory. We fail to understand that home care is an entry-level position for the workforce in Connecticut, occupied principally by first-time individuals and many immigrants to the state. It is a minimum wage, in many cases, position. In Connecticut, and I really feel sorry for us because we're really an outlier, there are no requirements in Connecticut for any home caregiver to have any training, any experience, a health exam. We don't require an E-Verify check. And while we do require background checks, they don't have any substance to that. So this bill attempts that. And we've got approximately, it's been estimated 30,000 caregivers at any one day in the state of Connecticut. And there aren't enough of them. My animal of care provider on my roster, generally I find caregivers out of state. For me to have someone come here to the state to have their fingerprints taken and then wait for them here to take a case, it's untenable. It would essentially put me out of business. I presently follow the Commonwealth of Pennsylvania regulations, which are worthy of looking at. It's a 2-tiered background check system, but it does involve the Pennsylvania State Police, and it does have restrictions on who could be placed at home. But I do national background checks, Social Security traces. I used to use Pinkerton. They sold their business to another organization, and I now use them. But every individual, every client that I work with gets a copy of the e-verification documents that travel with the prospective care provider. They get a copy of the background check and the Social Security trace. They get everything. They know everything about the caregiver. The challenge with the marketing piece, as Mark Mcgoldrick said very eloquently, it is also the fact that it lends itself to the fact that no caregiver has any training. We have people who need, people who are consumers who need as little as just a little bit of companionship up to full-time care because they're in bed. And if you have
Mr. Cholanski, we're at the 3-minute marker. If we can start.
Thank you. I'll finish up now, Mr. Clerk, Mr. Clark. But what I'm trying to say here is that the problem is much different. I've been saying this for years. We have no regulations on the people who provide care. All of our consumers are at risk. This is really an issue between DCP and DPH. It's how do you regulate home care providers and protect the consumers? Background checks are part of it, but we can't do it in a way that's discriminatory. So I'll be glad to answer any questions.
I'm sure DCP and maybe some members of this committee would probably prefer that this regulation be at DPH than DCP, and why it's there out here, I'm not sure. I tend to agree.
There's no place in the General Assembly that actually is the focus point for home care. The entire regulation, and Steve Hernandez really is the place that really is the guy who should take this on. I met with him just before COVID. He had 2 Yale University interns working with him, and they produced about 10 pages of research on the home care industry, and we started rewriting section 400O of the statutes. There's a lot of work to be done, and I'm beyond the scope of this hearing, folks, but it's a problem.
Send us what you want. We'll take a look at it. I don't see any questions for you, so thank you for your testimony.
Thank you very much, gentlemen, ladies and gentlemen.
Mr. Clark. Mr. Clark. Mr. Clark.
Surprised it took that long for people to make that joke. I've been laughing at that since day one. So up next is Joseph Markley. He called in, so I'll let him in.
Yep.
Still muted. He needs to unmute himself.
I'm sorry, I had previously withdrawn my registration for this.
No problem, Senator. Nice to hear from you. You are on.
No, I'm not testifying today. I have somebody else from our company will be speaking.
Okay, great. Okay, thank you. Appreciate it. Mr. Clerk, we can go to the next person.
Okay, so next is Jamie Arbor.
There she is. Ms. Barber, you're on.
Hello, thank you. Good morning, distinguished chairs and members of the committee. My name is Jamie Arbor, and I'm here to speak about HB 6100, sections 26 and 24. As a director for Connecticut's largest and most reputable non-medical community-based brain injury specific support provider, the Supported Living Group, I believe it imperative to request that your attention be drawn to the 2 specific requirements held within HB 6100 that have the potential to detrimentally impact those we support and our statewide employee population. HB 6100 section 26 proposes a significant elevation to the currently mandated comprehensive background checks being deployed within our industry, requiring instead FBI-based state and national level checks to be universally implemented. This is an unnecessary requirement. It is cost prohibitive, time and resource consuming, and offers no greater level of insight than the commercially available screening tools currently being utilized throughout the industry to review our applicants. Given the current tenuous operational climate being faced by providers throughout the care industry in Connecticut due to the ongoing COVID-19 pandemic and the imbalances occurring between minimum wage increases and service reimbursement rates, it would appear ill-conceived for the screening mandate associated with Section 26 to be implemented. The mandate will grossly increase staff onboarding costs and timelines while placing huge administrative burden and its associated costs on the state police locations, which the community-based staff population will be required to attend for their fingerprinting. In addition, there are unrecognized consequences of staffing delays associated with these screening checks that are going to be utilized, also having the potential to leave vulnerable individuals throughout our local communities without staff supports, greatly elevating their risk of injury, exploitation, and further cognitive and physical declines while they wait for staff to be onboarded. In terms of Section 24 and its attempted elimination of community home care providers' utilization of specific service-associated terminology in their marketing efforts, this limitation would drastically impact the identification of in-home community support options for an ever-increasing population of vulnerable adults due to unnecessary and ill-advised semantical stance. I mean, clearly our staff members are trained from the time they join the agencies and throughout with ongoing mandated trainings. Therefore, to remove the ability for the agencies to then document this training will impact other people's abilities to find the services they need for their family members who they want to keep in the community, who they want to allow to stay in their home with staff supports. An inability to say that our staff are trained in specific dementia care or Alzheimer's care or even traumatic and acquired brain injury care is deeply, deeply concerning because, as I said, we are mandated to provide trainings. To remove that would be detrimental to the industry as a whole and also be detrimental to this specialized client population who have a significant level of care needs. That's all I wanted to say today, and I appreciate the time that you've provided to listen to those statements.
Perfectly done. Thank you. Time limit. I don't see any questions for you either. So thank you very much for your testimony.
Thank you. Appreciate it.
Mr. Clerk.
Up next is David Humphrey.
There we go. And you are on.
Good morning. Distinguished chairs, members of the committee, good morning. Thank you for the opportunity to speak on SB 693. My name is David Humphrey, and I'm CEO of ECPPF Holdings, one of the largest Planet Fitness ownership groups in the country, with 106 gyms in 6 US states. But our headquarters are right here in Orange, Connecticut. We operate 32 Planet Fitness gyms in every corner of Connecticut. We employ about 400 people here, and I'm proud to tell you we have about 170,000 Planet Fitness members here in Connecticut. We can support the idea in Section 1 of SB 693 that members who want to cancel their gym membership should be allowed to do so via email. That's not currently our official policy, but during the pandemic, we've been allowing people to do it. So we have no problem with that becoming required by law. But Section 2 of SB 693 is unnecessary and unreasonable because there are already strong protections for consumers on those issues. On any day when you might come in to join a Planet Fitness, we always offer prospective new members the option of a membership where there's no committed term at all. You pay a little more for a no commitment membership, but then you could cancel at any time. And in our membership agreements, we say very clearly to new members who choose a membership with a 12-month commitment that their membership, quote, will continue on a month-to-month basis at the monthly rate above until you cancel. That is completely transparent in bold print. And there's nothing unusual about this approach. Hundreds of companies keep billing people every month or every year until they cancel. Just in my family, we have Netflix, internet service, T-Mobile phone service, my subscription to the Hartford Current, Amazon Prime, DirecTV, all of them are services that will continue billing us every month until we cancel. There is nothing wrong with this. But Section 2 of SB 693 would require just gyms to contact every member about 10 months after they join and remind them that they agreed 10 months ago that they'd continue as members and be billed every month until they tell us to cancel them. And not only would we have to remind people, they would have to answer and give us explicit permission to keep them on as members. And if they didn't read the emails we sent them, or if they didn't take the time to reply, we would be required to cut them off and terminate their membership. Is there going to be a law that forces phone companies to cut off people's phones after 12 months unless they write into the company asking them to please keep my Verizon account open? It is not reasonable to single out one industry when dozens of industries use the same billing practices, and it is not necessary when strong protections already exist. I'm conscious of time, but I hope you'll read more details in my written testimony. So thank you for deleting Section 2 of SB 693, and I'd be happy to take questions.
I don't think we're quite there yet, but I appreciate the sentiment. Senator Witkos.
Thank you, Mr. Chairman. Thank you, Mr. Humphrey, for testifying this morning. Would you be opposed to language that still allowed an individual to send an email to cancel their contract after or for non-renewal, I guess not the contract, but on the month-by-month basis, rather than having to go in person or put a handwritten letter?
Be opposed to that. What's important to us is that we have some sort of written record, and an email is a written record. And that I want to avoid, just to be clear, is a scenario where someone walks in and says, hey, 6 or 8 months ago, I asked you guys to cancel my membership, but you didn't do it, so I'd like to have a refund for the last 8 months. Obviously, most people don't do that, but we live in a world where some people do. And we'd like to have a written record, either in a letter or an email. And as I said, we'd be willing to accept the terms of Section 1 of the bill where it talks about canceling by email. Love to work with the department on the language, but it's not a difficult concept. We can absolutely agree to that.
And would you be willing to make it easy so somebody could get the email address if they wanted to do that? I found that sometimes through promotions and advertisements, you'll get some, a letter, but then you can't respond to that. It says, do not reply to this email, or it's just it's a statement. It's not an email account, which could confuse folks that are not very computer worthy, but make it so that it's easily discernible. If somebody wanted to, then they'd have the ability to do that.
I think that's entirely reasonable. And we could put it right in the contract. Again, we have all kinds of protections written right into the agreement. People actually have to sign a bold statement saying, I have read and understood the cancellation rights and billing policies on the front and back of this agreement. They have to initial it. So we can easily put the email address as you're suggesting, not a problem. We're happy to, there's a phrase in Section 1 about how they want to propose a section heading called buyer's right to cancel. Not a problem. We're entirely reasonable about things like that. But that's very different than requiring us to contact every member who joined 10 months ago and say, hey, you do remember what you signed, right? And now you have to reply and you have to positively affirm that you want to stay on as a member, or else we've got to cut you off. It's Section 2 that we're concerned with.
Right. Okay. Thank you. Thank you, Mr. Chairman.
Thank you.
Thank you, Senator. Senator Kissel, please.
I'm sorry?
You have your hand up. Do you have a question?
Yeah, I do.
Please.
Just a quick question. You listed off a litany of businesses that use this policy on a regular basis. I've been on this committee long enough that we've had complaints from from people that are subject to trash haulers, where they had rolling 3-year contracts, and businesses would come to us on the general law committee and say, hey, I didn't know I was going to get re-upped for another 3 years. Are you aware of that?
No, I don't know the first thing about the trash hauling industry, to be honest with you, sir. But I would just add that in our case, we have nothing longer than a 12-month agreement, and people get copies of the agreement. I mean, it's not, there's absolutely we never bill anyone more than 12 months. And then once they renew, they go just month to month.
Okay, thank you, sir. Thank you, Mr. Chairman.
I do not see any more questions for you, and we look forward to continuing to work with the departments on this language. Thank you.
Thank you so much.
Mr. Clerk.
Up next is Jane Borda.
Can you hear me?
Jane, welcome. You are on.
Thank you. My name is Jane Bordeaux, and I want to thank all the members from the General Law Committee for the opportunity to speak today. I am a senior manager at Bantam Wesson. We are a family-owned energy company that's engaged in the sale of heating oil, bioheat, and propane with locations in Waterbury, Cheshire, Canton, and Bantam. We've been in business for 90 years, and we are in support of SB 152, an act concerning electronic delivery tickets for gasoline, kerosene, fuel oils, or similar substances. I did hear in the very beginning that most people seemed in favor of this, so I'm not going to take a lot of your time. I want to point out that most customers get electronic confirmations of the purchases of almost every product and service they do receive today. And the fuel industry has not kept up with that because of the Connecticut law. We are asking for to respond to our customers' request and treat the purchase of heating oil the same way as other products are treated. COVID has really highlighted this issue for us. Most customers no longer want to come to a door and take a ticket. Tickets fly away, they end up in the road. Someone had mentioned earlier, tickets pile up when people are snowbirds and head to Florida, and that's not a good thing for safety in a home. And we have to stop our trucks, run the ticket, they idle, and as an industry that's working with biofuel to save energy, we keep them. We have 18 trucks for X amount of minutes that just idle in someone's driveway while we're running a ticket off, getting it to whichever door they've asked us to leave it at. And that's not good for the environment. I guess we've averaged it out to 5 minutes each call that you go on. And I guess every person who delivers fuel in the state of Connecticut, that's a whole lot of trucks idling and a whole lot of non-clean air. And just excuse me, because I'm trying not to make this too long. I'm trying to scan over my notes. Connecticut Energy Markets Association, we sell approximately 450 million gallons of heating fuel per year with an average of 125 gallons on a delivery. That totals 3.6 million total deliveries statewide. So for every customer who takes an electronic delivery ticket, instead of leaving a ticket at their house, will result in 12,500 total days of saved time, of reduced diesel emissions, and not to mention saving of paper. We do ask for your support in SB 152. Customers, they work with email every day. Customers here who don't work with email can get a ticket at their request. We can, it's an opt-in, opt-out, so we can do whatever works for our customers. But the majority of customers do everything on email, and we'd like to be part of that same industry.
Thank you. Yes, I think we can expect this probably to fly very quickly through the committee, and then our hope is that it'll be advanced rather quickly and without any issues through the General Assembly. So thank you for your testimony on this issue.
You're very welcome. Thank you for your time.
Thank you, Mr. Clerk.
Up next is Tracy Wadach.
You're on mute, everybody. Senator. Tracy, you there?
Okay, yep, I am here. Can you hear me okay?
Yep, you're good. Welcome.
Great. Thank you very much. Senator Maroney, Representative D'Agostino, members of the General Law Committee. My name is Tracy Wadach, President and CEO of the Connecticut Association for Healthcare at Home. Our membership supports both the licensed and certified medically oriented home healthcare agencies and the Department of Consumer Protection, or DCP, registered non-medical homemaker companion agencies. And these are the agencies who provide critically important supportive services in the community. The general public is often confused about the differences between these two types of home care agencies available in the community, but their goal is to help people age in place in their setting of choice, their own home. Regardless of type of home care agency, it's imperative that we encourage only the regulations and statutes that will continue to promote aging in place and not find ways to discourage its growth or access to these much needed services. We oppose the language in sections 24 and 26 of HB 6100 as it does exactly that, discourages meeting consumers' needs for in-home care to meet their own personal choices. DCP has made it clear to homemaker companion agencies that they should not use certain terms in advertising, such as dementia and memory care. Their reasoning has been explained as dementia and memory care or Alzheimer's care is a medical approach to care and should not be allowed by a non-medical homemaker companion agency. Now DCP is trying to legislate this interpretation. Yet with the aging demographics comes an increasing prevalence of dementia. For those with dementia to be able to receive appropriate non-medical care, supportive in the community, the caregivers must be trained in appropriate communication and personal care approaches, neither of which are needed by a medical home health care agency. These services are not medical services and are best provided in a long-term supportive care environment by a non-medical home care agency. As for the proposed language to implement federal and state background checks in section 26, this includes the fingerprinting at one of the 13 state barracks. This too hinders the ability to provide timely care in the community and discourages potential workforce from being hired. Our DPH licensed home health and hospice agencies have a similar yet far more refined process in place, including the ABCMS portal, which offers registration of an applicant, easy lookup, and scheduling of the fingerprinting process. It certainly has its challenges, but once the entire process has been completed, an individual's results are good for 3 years, which is vital to provider ability to hire timely and assign cases. This bill asks for a process to be completed for each and every hire. Reality is that caregivers work for several agencies at once and seek additional employment to make ends meet. This would be extremely time-consuming and costly. In addition, the initial screen always a challenge, but both the candidate to get to the barracks, transportation can be a barrier, and it costs the employer nearly $120 per screen, which is about 4 times what the homemaker companion agencies currently pay for their comprehensive screen. A screen that gives immediate results versus fingerprinting process, which is anywhere from 48 hours to 2 to 3 weeks. Again, the proposed process will keep consumers from receiving much needed care in the home. I am working with the HCAOA Association. Mark Mcgoldrick had testified earlier. Just wanted to let you know, we urge you not to pass this proposal as written. Thank you for the opportunity, and I'm happy to answer questions.
Thank you. And not seeing any questions for you. Thank you for your testimony.
Thank you.
Mr. Clerk.
Up next is Sam Galt.
Thank you.
Can you guys hear me?
I can hear you. Sam is, why don't you still in the room there? So we gotta just make sure Sam is in and Mr. Galt is in.
Yep.
Yep.
Can you guys hear me?
Yeah, we can hear you. Great. Welcome. Thank you.
Oh, good. Thank you. Thanks for your time, everybody. So I'm Sam Galt. I'm the president of Galt Family Companies and Galt Energy. We're a 6th generation company here in Westport and deliver heating oil, propane, do HVAC services, as well as generators in Lower Fairfield County and Upper Fairfield County. And we roughly have about 30 to 35 delivery trucks. And I just wanted to reiterate all of Jane Bordeaux's comments. I don't want to spend a lot of time for you guys because everything she hit on is exactly what I was going to hit on. I just like to reinforce one component there, And that has to do with that, energy companies are really becoming more environmentally friendly. Not only will this bill allow for a great reduction in paper, but it will reduce the time delivery trucks spend idling at customers' homes. I know she mentioned that. I just want to, that's the one point I want to just reiterate to the committee. Currently, after the delivery is complete, the driver returns the hose to the truck and goes into the truck cab to print the ticket. Then he walks the delivery ticket back to the home to drop off to the consumer. The minutes that the truck spends idling while the driver drops the ticket at the home would be eliminated. Multiplied by thousands of deliveries in the state of Connecticut every day would be a huge, huge savings. And I think it's something that you guys should really consider. So as you can tell, that I'm very much in favor of SB 152. And again, I'm reinforcing Jane Bordeaux's comments from the Bantam Wesson team. They've done a really nice job of outlining everything that I had in my remarks for you guys. So I'm available for any type of questions that you may have for me. Thank you.
Thank you. Yes, there's certainly some broad support for this. I do see a question from you from Senator Kissel, please.
Hi, Sam. Good morning. Isn't there a rule or a law in Connecticut about idling? And how do you guys get around that?
Well, I think there is, Senator Kissel, that we're supposed to stop idling as much as we can, but it's just the reality of the industry that we're in. The guys are hustling out there. So, we have, most of our guys are doing somewhere between 25 and 35 stops a day. So to turn the truck off on every single delivery is actually probably not realistic. So the fact that this bill actually helps us dramatically, when we finish and we bring that hose back to the truck, he gets in the truck and he goes on to his next stop. But just so you know, the truck has to be running, okay, during the delivery process, because you need the engine to be running in order to pump the fuel, and it powers the pump to get the oil into the tank.
All right, good to know. My house gets natural gas. The people across the street get oil.
Mm-hmm.
People next to me get oil. I've seen it all the time. This just seems like an environmentally friendly bill that should have legs. And so I appreciate your testimony. Thank you, Mr. Chairman.
Thank you, Senator. And seeing no further questions for you, thank you for your testimony.
Thank you.
Mr. Clerk.
Up next is Eric George.
Can you hear me?
And I can see you. You're on. Welcome.
Thank you very much. Senator Maroney, Representative D'Agostino, Senator Witkos, Representative Retigliano, and members of the General Law Committee. My name is Eric George. I am the president of the Insurance Association of Connecticut. The IAC would like to offer testimony on House Bill 5303, which would prohibit telemarketing for automobile warranties, insurance products, and utility services. It's safe to assume that most consumers, maybe all, may feel that they already are receiving too many unsolicited calls from entities attempting to engage them in commerce. And 5303 has been introduced to address this. Upon learning of House Bill 5303, I did contact its chief sponsor. He conveyed to me his frustration with unsolicited calls and explained that one of his primary goals is to combat fraud. He also emphasized to me that he does not intend to impede good faith business practices. I share, and the IAC shares, both his commitment to good faith business practices and opposition to fraudulent practices. I further understand that this bill is an attempt to limit these calls. However, given that it is only in proposed bill format, it's unclear as to precisely what it's going to do and what it will accomplish. I want everyone on the committee to understand that the insurance industry is one of the most heavily regulated industries in the state of Connecticut and the country in general. Our companies are regulated by the Connecticut Department of Insurance and subject to continuous market conduct examinations. It's also important to note that insurance companies already comply with the rules of the National Do Not Call Registry, operated by the U.S. Federal Trade Commission. Given the intense regulation and scrutiny that the insurance industry is already subject to, We ask that in the event that this committee chooses to move forward with House Bill 5303, that reference to the insurance industry is removed. I appreciate your time, and I am happy to answer any questions that you may have.
Senator Kessel, please.
Yeah, thank you, Mr. Chairman. I just want to say hi, Eric, and I hope you and your wife and your children are doing great. It's good to see you again.
Thanks,
And
Senator.
you bet. And just if you have a direct email to my office regarding your issues, that would be helpful.
Okay. I really appreciate that sentiment. I will convey your salutations to my wife and my family, and we will contact you. I appreciate that comment, sir.
You're welcome. Thank you, Mr. Chairman.
Thank you, Senator. Senator Wickos, please.
Thank you, Mr. Chairman. Eric, good morning.
Morning,
I think that a lot of the folks, me included, were frustrated at, and it happened to just start up, seems like over the past few months, all of a sudden regarding your automobile warranty is expiring, and that seems to be one of the constant ones. That's why that was mentioned specifically in the bill. I don't honestly recall getting any phone calls myself from anything regarding insurance. But are you aware, or does your association get notification of any campaign that's going out there from any insurance industries about robocalls or telemarketing campaigns prior to them happening?
The short answer is no, we're not. But I want to give you a personal experience. I am sharing your experience with the car warranties. They seem to come in waves, where I might go a few days without getting any, and then I'll get probably half a dozen to maybe even more than that, maybe 10 in succession. And I do feel that they've learned well how to geo map and geo target folks. So you'll see I live in Glastonbury, and I might see a number that is a Glastonbury number. So it might sort of influence me that I might want to pick that up. I get those, and I'm as frustrated as everybody else. I have never received an insurance-related robocall. I am not aware of any campaign going on, but the real concern here was it happens whenever we have a proposed bill. A proposed bill just is an idea, and where it goes from there is where the rubber meets the road. And that was where our concern is. I mean, it is a direct prohibition on telemarketing for insurance products. That's rather broad. So we would like, again, everybody to appreciate the level of scrutiny that we're currently under with the department and everything, and all of our market conduct examinations. We are analyzed quite heavily.
I get it. And to use your own words, you were frustrated by these automobile warranties, as is, I think, a lot of the members on this committee. So that's the nexus for the bill as to why it's before us. And to be honest with you, it needs some work. It's not fully drafted yet, and take your comments into consideration, but we're still trying to get at the root of the frustrations of a lot of members, not only on this committee, but other committees that are receiving the same type of robocalls. And you don't even understand if they're valid or not. It's out there, and it's extremely frustrating because, again, as you correctly stated, they're using local pre-digit numbers. So it looks like it's somebody from your community calling you. So you answer the phone, and then you get tied up in that phone call. But certainly your comments are well received, and we'll take that into account if the bill moves forward. Thank you, Mr. Chairman.
Thank you, Senator.
Thank you. Seeing no further questions for you, thank you for your testimony.
Thank you.
And just for our OLR staff, Duke and Julia, if you guys could dig up, I think you've researched this before, but it'd be helpful to recirculate memos, or if you have them, about just the interplay of federal and state law here, and what precisely we can and cannot do given the TCPA Act and other, and just federal preemption in this field versus what we can do as a committee. That would be helpful for us. Mr. Clerk, next.
Up next is Leslie Anderson.
Morning, can you hear me?
And see and hear. Welcome.
Great, thank you. Thank you, Mr. Chairman, for the opportunity to speak with you today about SB 152, an act concerning electronic delivery tickets. My name is Leslie Anderson. I'm the president of the Propane Gas Association of New England, and we are a regional alternative energy trade association representing members of the propane industry in the 6 New England states. We exist to serve the industry by promoting safety, education, and public awareness, and our membership includes propane companies and suppliers, including many small companies that are often family-owned for many generations. Propane is a clean alternative fuel recognized by EPA in the Clean Air Act, and it's also an essential backup for our ever-increasing use of the electrical grid. Using clean propane energy accelerates decarbonization, and access to clean propane ensures environmental equity in the state of Connecticut. We support this bill. Our customers frequently complain to our member companies about leaving paper tickets following a delivery. Customers request that we stop leaving them, that we leave them in a mailbox. Both of these are illegal currently under the law. Customers also complain when they're hung on their front door, as it clearly announces the customer is at home, and this is a security concern when traveling or away from vacation, which has been mentioned previously. We also have customers that complain when tickets are hung in plastic bags on the doorknob that we're wasting plastic. And this is often necessary either to protect the tickets, depending on the type that the company is using, from winter and rain. And then also with COVID, a lot of companies have gone to that because it's perceived to be safer, you know, from a transmission standpoint. I did want to say that during the pandemic, we have received more complaints than ever before regarding tickets. Customers didn't want them left at their locations at first because of fear of transmission. And they've really been demanding across New England that we have electronic versions and as a solution, which I believe everyone agrees is absurd in this day and age that electronic tickets would not be acceptable. We have a lot of companies that have websites or apps already where delivery data could be accessed by the customer as soon as it's uploaded, and other companies could easily mail or even email tickets following deliveries rather than leaving them at the door. Besides saving amount of paper, I did want to concentrate on one other point. I served for 15 years as a risk manager and in-house attorney for a large propane company in the northern New England states. And we had frequent injuries from employees who were falling through porches when they were delivering tickets, or tripping over or slipping on ice when they were walking up to the front door, tripping over kids' toys that were covered in snow. I mean, there was a substantial amount of injuries that happen every year, slips, trips, and falls to our employees during this step of taking the ticket and putting it onto a door. So that's another reason that I think it would be beneficial both for our safety and for the safety of our customers who are concerned, especially during COVID, with the risk of exposure. And it's good for the environment. So for these reasons, we respectfully request that the committee pass SB 152, and I thank you very much for your consideration.
Thank you. A lot of good reasons for this bill. I think we're seeing that. I think you're hearing from the committee that we agree. And seeing no questions for you, thank you for your testimony.
Thank you.
Mr. Clerk.
Up next is Kenneth Dellery. He's in now.
Here's got on mute.
Can you hear me now?
You are on. Welcome.
Okay, thank you. Good morning. My name is Kenneth Dellery. I am here today on behalf of the Connecticut Manufactured Homeowners Alliance, which is identified in state statutes as representing the interests of mobile home park tenants in the state. I am also a member of the DCP Mobile Manufactured Home Advisory Council, and I reside at the Cedar Springs Mobile Home Park in Southington. Thank you for the opportunity to speak to the committee today regarding provisions of House Bill 6100. As you may know, mobile homes constitute one of the few sources of unsubsidized, low-cost homeownerships in Connecticut. One of the goals of the Homeowners Alliance is to ensure that mobile homes retain that status going forward. One impediment to that goal is the unique nature of the landlord-tenant relationship between mobile home park owners and their tenants, who in most situations own their homes, but lease the land the home rests upon. When disagreements arise in a typical landlord-tenant relationship, the tenant can pick up and move elsewhere. However, the cost of moving a mobile home, together with limited availability of alternative sites, makes a mobile home next to impossible to move when an impasse arises. In this situation, the park owner nearly always has the upper hand. Accordingly, mobile home tenants rely upon statutory and regulatory protections enacted by this legislature, recognizing the unique status of mobile home park tenants. Naturally, the Alliance has an interest in any legislative action that could undermine those protections. According to our understanding, sections 36 and 37 of this bill are intended to strengthen DCP enforcement powers and contain some provisions we support. However, we believe there are a couple of provisions we think could cloud the intent of existing enforcement capabilities. For example, DCP is to inspect our parks once per year. Section 36 allows the DCP to do those inspections year-round, but has language that could be interpreted as deleting the yearly inspection requirement. Section 36, these annual inspections are critical for maintaining the parks, and we ask that you rework the section to ensure continuance of annual inspections as part of the license renewal process, and make sure DCP retains the power to withhold license renewal if a park is not compliant after an inspection. In section 37, we ask that you make sure the DCP's emergency powers include the ability to act in any emergency threatening the health and safety of residents of mobile home parks, not just the emergencies identified in the current statute. For example, in the past 2 years, failure to remove dangerous trees put residents' lives at extreme risk when trees fell on their homes on at least 2 occasions. We urge you to make these changes to sections 36 and 37 when deliberating on this bill. And thank you again for the opportunity to speak today, and I'll take any questions you may have.
Not seeing any, so well said. I appreciate you doing that in a concise manner. Thank you. Oh, I'm sorry, Senator Wickos, I do see a question for you.
Yeah, thanks. Sorry about that. Just a real quick question. Connecticut Legal Aid had testified that they felt that there was a very nuance between investigation and inspection. And I don't know if you had a chance to listen to Mr. Podolski's testimony, but I was wondering if you could comment on if you think that that's something that really needs to be tweaked in that section.
I have some familiarity with it. We have been exchanging emails on this over the last 24 hours with one of Commissioner Siegel's staff. It's a fine line. I do think if, from our perspective, if there was a little bit of tweaking so that the investigations can continue to happen on a regular basis. They have some issue with the staff that does investigations and the staff that does inspections. And they're concerned that we not tie up their investigation staff with on-site inspections. I'm not exactly sure about that works, but we're talking with them about that language, and I think it can be worked out.
Okay, great. The committee would love to have you guys reach some language.
Yeah.
Send it over.
We have a meeting scheduled, I believe, within the week on all this stuff.
Excellent. Thank you. Thank you, Mr. Chairman.
Terrific. Thank you for noting that, Senator. Seeing no further questions, I'll thank you for your testimony.
Thank you.
And Mr. Clark.
Up next is Ann Wilson.
Good morning. Can you hear me?
And we can hear you, yes, and I can see you, so you are on. Welcome.
Wonderful. Good morning. Thank you, Chairman, and thank you, committee, for allowing me to speak here today. Again, my name is Ann Wilson. I'm here representing Companions and Homemakers. We are one of the largest home care non-medical companies here in Connecticut that's been serving the entire state for 30 years now through 10 branch office locations, and we employ about 3,000 hourly and live-in care workers. My capacity is to oversee client services as well as recruiting. So I'm interacting with clients, caregivers and their families on a daily basis. So I have a very personal and very vested interest in what's going on. So I'm here today to talk about what we feel the impact of Section 26 of House Bill 6100 would do to the industry as a whole. I don't think it's any surprise to anybody that recruiting and retraining and hiring good quality home care workers is a challenge. It's a challenge nationally, and it's no different here in Connecticut. The number of available resources to provide care is far less than the rate at which the need for home care is increasing. So we're impacted by challenges already. COVID has only exacerbated that. What it's also done is it's increased the level of people needing care and needing more critical supportive in-home care. When I say that, I mean that, if we take 10 new clients on board, 8 of them require personal care. So having an available pool of resources and immediate resources is essential to being able to provide clients with the care that they need in their homes and provide that care immediately. When a situation arises, they don't have days or weeks to wait for an agency to put care in place. They need care now. What we're already doing, putting quick care in place doesn't mean a lack of quality or a lack of thorough vetting. Like you, that's our number one priority, to ensure that we have thoroughly vetted caregivers going into clients' homes quickly for the protection of our clients. Adding an additional step, especially now, is really going to impede that and make it increasingly difficult. What we've had in place under the state umbrella now for comprehensive background checks and Social Security checks, all of those things have worked very effectively for the past 10 plus years. To now put this extra step in place, I think is also going to be a deterrent to people wanting to come into this field and doing these things. So what we're asking is not why this, but why now? We can't afford to face one more challenge. We just want the due diligence, the thorough exploration, looking at all the avenues so that we can make sure that any plan that we're putting in place is for everybody's protection and well-being, but it's thoroughly looking at all of the options, from the protection of our vulnerable elderly population to also the several hundred home care agencies that employ these critical care supportive workers in Connecticut. Thank you. And I'd be happy to answer any questions.
Nicely done. That's how testimony should be done. And not seeing any questions for you. Well done. Thank you very much.
Thank you.
Mr. Clerk.
Up next is Anna Dorgazi.
I can see and hear you, Anna. Welcome.
All right. Wonderful. Good morning. Good morning, Representative D'Agostino, Senator Maroney, members of the committee. My name is Anna Dorgazi, and I'm one of the policy directors at AARP Connecticut. We submitted written testimony in support of sections 24 and 25 of House Bill 6100. I want to use my time today to just briefly elaborate on our support for Section 25, which would require homemaker companion agencies to conduct a state and national background check on prospective employees. I think the question here that we need to ask is, what do we hope to accomplish with background checks? Background checks are not a way to assess the skills or competence of the person providing a service. They're a tool that we can—
Storm governance meeting and tomorrow's working meeting.
Make sure you're on mute, everybody. Okay. Go ahead, Anna. That won't eat into your time. Go ahead.
So background checks are a tool that we can use to try to figure out whether or not a worker can be trusted to provide, trusted to be safe or to act honestly or respect the home and body of the person in their care. Background checks are absolutely not a perfect tool. Plenty of good people have made mistakes in the past that don't look good in a background check. And plenty of people who really shouldn't be trusted look fine when you look into their backgrounds. But that said, homemaker companions do have the same level of access to a person's home, property, and body as other job titles like home health aides that go through more rigorous screening processes. So if our goal in using a background check is to determine whether or not we can trust a person to act honorably with a vulnerable person when they're unsupervised, it makes sense for us to be consistent in the type of background check that we're using, regardless of the type of work that's being performed or the job title of the worker or the state agency that regulates the employing business. Most people want to receive care in home and community settings as they age, and homemaker companion agencies provide really important services to make this possible. AARP's goal in supporting House Bill 6100 is absolutely not to make it more difficult for these agencies to hire good workers in a timely manner and to provide their valuable services to the community. We agree 100% with the previous comments about the need to build and support this workforce. However, we do occasionally hear from consumers who have had a negative experience with homemaker companions, and they're really upset when they learn that these workers were screened using a different standard than other home care and long-term care workers. I don't want to say that a state and national background check is inherently safer than a comprehensive background check, which is the standard that's used now for homemaker companions. But I do think that it's reasonable for consumers to expect some consistency in how we screen the workers that come into a person's home. So I'll leave my remarks at that. Our written testimony elaborates a little bit more. Thank you for the opportunity to speak today, and happy to take any questions.
I do have one for you, just a precursor comment, which is just simply that I think we're all on the same page here in terms of the committee wanting to make background checks, and hopefully under Senator Witkos's oversight in particular, we can figure out a way to do that in the most efficient manner that doesn't, as you mentioned, impact the ability of people to actually seek this work. So I'm really hopeful on that. I actually had a separate question for you. You didn't testify on it, but I didn't, and so please feel free to say you don't have a position, but there's some other testimony about the advertising and this attention I'm starting to at least get a sense of with respect to, we don't want these agencies advertising that they're doing, for example, Alzheimer's care because they don't offer medical services. At the same time, we recognize that there is a non-medical component, and people are often seeking some just general assistance day-to-day for people with those ailments. And then what we're hearing from the department is that can lead to complaints saying, I thought I was getting medical care, and they're not. And I think we want to be sensitive to both the ability of these businesses to advertise their services, but also consumers to be informed. Do you have a view on that? And if not now, if ARP could think about that and give us their thoughts on that issue, it probably would be appreciated.
Yeah, so we do, we support Section 24 of the bill with the caveat, that I think I saw in some of the submitted testimony from some of the homemaker companion agencies. It'd be really helpful to clarify what is meant by, words relating to medical or healthcare licensure services. I think the entire home care market can be really difficult for consumers to navigate. I know just in my own research, trying to understand this bill and trying to understand, homemaker companions, home health aides, homemaker companion health agencies, registries, why I think it's confusing for people to understand who provides what service. I think it's confusing for them to understand, what due diligence goes into vetting these folks. I think it's very confusing, and I have heard anecdotally of problems that arise from having this goes well beyond the scope of 6100. But when problems do arise, it can get really complicated that we have two different regulating agencies for these services, so DCP and DPH. But I think anything we can do to certainly be honest with consumers. So, we're not having agencies that don't provide health services advertised that way. But, I do appreciate that some of these home care companion agencies do invest time in helping their staff understand some of the social components of things like Alzheimer's and dementia. And that's important. We want folks to invest in training for their staff that's going to make them responsive to those needs, even if it's not a specific, health, if they're not providing healthcare. So we don't want to do anything to disincentivize providers from providing that additional training or for telling consumers that they have made that investment. So I think it's just a matter of, threading the needle so that consumers have information about exactly what they're getting, but that we're not so stringent about it that we're disincentivizing certain providers from training and educating their staff. I hope that made sense.
Yeah, I think we appreciate there's some tensions here, so thank you. Senator Witkos.
Thank you, Anna. And I don't know if you're going to be able to answer this question. I kind of piggybacks on what Chairman D'Agostino was speaking about, and you had mentioned it could be confusing to folks when we have two licensing departments, whether it's DPC or DPH, DCP or DPH. And my thought is that if you are, and this is a guess, and I don't know if you could say if I'm right or wrong, if you're under the Department of Public Health, chances are that the services that you provide will be more costly than an agency that falls under DCP, because there's the medical component versus somebody that, and I don't mean to diminish it, but you're just a home health aide where you're just helping them because they just need, the example this one woman gave of her dad could get out of a chair, but he couldn't negotiate himself walking and just needed somebody there to assist in that manner. So that from a consumer's perspective, that if you don't know where to look, you could be paying for something that you really don't need as a family for a loved one. And so I guess I would look towards my question was, it's probably more expensive for DPH than DCP, if you know that one. And B, if we could come up with something, even if the state sponsored something, a website that gave, they could do the advertisement, say Alzheimer's, caregivers, or whatever you want to call this, whatever we determine it to be. And then all these other agencies could be listed, their agencies underneath it. So it gives somebody, in the example from California, looking for assistance for a loved one here in Connecticut, who do they call? And they're doing Google searches, and because they're so far away, they just cannot deal with it. And sometimes it's something that's imminent. If there was a fall and they're getting released from the hospital, they got to get somebody there. So I understand the urgency behind it, but any thoughts you can give to that?
Yeah, so I don't have enough information to speak to, whether DCP regulated agencies have higher or lower costs than DPH regulated folks. I would guess just intuitively, if you're providing, kind of RN level home care, you're looking at a different price point than, than other services. But yeah, I completely agree on, the need to make all of this a little more consumer friendly. I think the other component, in addition to a lot of folks out of state trying to navigate Connecticut's home health or, home care market, I think you also have people who are typically like in an immediate point of crisis. Usually there's been some kind of, some kind of fall or some kind of diagnosis or something where the family is already, kind of having a difficult time. And that's what the moment when they're trying to educate themselves, trying to make these decisions. So anything that we could do as a state, to help consumers understand the general landscape and give them information that they need to make the right choice for their family, I think would be really helpful.
Yeah, I'm thinking.
Thank you, Mr. Chairman.
Thank you. Seeing no further questions for you, thank you for your testimony.
Thank you very much.
Up next is Camille Gardner.
Just remind committee members to make sure you're on mute. Camille, we can see and hear you. You are on.
Good morning, everyone. Thank you to Chair and committee for allowing me to speak today. My name is Camille Gardner, and I am the owner of Care for You LLC in Bloomfield. I actually won't go over everything that everyone, the numerous home care agencies have discussed already so far, but I did want to speak a little bit towards the Alzheimer's DCP position on us being able to post that we're Alzheimer's agency and we do Alzheimer's care. I myself actually took a training through the Alzheimer's Association so that I could train the caregivers that work with us to be able to understand the clients that they're caring for. And I was specifically told that what we do is we clean houses and we run errands, and so no training is needed. But majority of the people that we care for, they have some type of Alzheimer's dementia, and it makes it very difficult for us to effectively care for these individuals if we don't have an understanding of what they're going through and what they're experiencing, even when it comes to the family members. So being able to administer this training to caregivers, it makes a huge difference. And us not being able to put that on our website, I now have to, was told that I need to remove all of this from the vehicle. We have a vehicle, we have to remove it from our website and from all of our publication, which we have been given 30 days to do. It makes it very difficult for us as an agency, as well as the families who are looking for someone who is able to understand what their loved one is experiencing. I do feel that there are a lot of challenges that we face as a home care agency. And another thing is the reimbursement for us, especially from Medicaid as a non-medical agency, is very, very low. And that limits the quality of caregivers that we get, to be honest with you. We have to put time into training these caregivers. And then even when we put the time into training these caregivers, we don't get reimbursements that are substantial enough to be able to pay them so that they will want to stay long enough with the clients that they are with. And it creates a problem for us, high turnover. We continue to retrain caregiver because they will come and they will leave and go somewhere else for an extra 10 cents. It's just one more thing that we are struggling with. And that's pretty much all I have to say.
That's well done. Thank you. Senator Wickos has a question for you.
Thank you, Mr. Chairman, and thank you, Camille. A lot of the HCAs came on and testified against Section 26, which is the background check portion. But you testified now that you have a very, very high turnover rate, and they leave for a variety of reasons. Mm-hmm. And don't you think that it's important to, with such a high turnover rate, that you gotta, it may be time consuming to some degree, it may be a cost factor, but to make sure that you've got the right people doing the right job. And it's not just saying if you've ever been arrested. I mean, it's very specific in the types of crimes that you would be ineligible for the job if you've committed within the past 5 years.
I agree that we definitely need to do an extensive background check. But I'm going to tell you right now that the extensive background check doesn't change the pay rates. And it doesn't change the amount of training that we can provide to them. So I think there are other issues that are just as important as the background check for these individuals that we are hiring. And I do believe that the background check is not going to change the fact that we have high turnover rate, because there are other factors that's leading to the high turnover rate. We also use Checker, and we pay to do the, I know Mark spoke about it before, it does, the statewide, the Social Security, right, and all of that. We also use the same thing. We still see a high turnover rate.
Let me ask you this, if you could. spoke about training a couple of times now. What's involved in the training, and is it by the individual ailment of the client, or is there a general amount of training you provide each person when they come on board?
So we are credentialed to provide services for Connecticut community care, Connecticut home care program clients, and they required us for us to have annual training. Some of those training that we do, communications training, how to personal care. One of the training that I took personally was the habilitation training through the Department of through Alzheimer's Association, which allows me to train a caregiver to say, okay, this is how you handle a client who's very upset because his wife is taking too long to come home when his wife actually passed away 10 years ago. The caregiver, if we don't train them how to do these things, or how to, there's, even though they're sitting there with the client and they don't have to, do any medical related services for the client, if they're sitting there with the client and the client is having, behavioral episode because he's waiting for his wife to come home, and his wife passed away 10 years ago. If the caregiver doesn't know how to handle this situation, it's a chaotic situation.
Right.
She's just going to try to calm him down, and she has no way of doing that if she doesn't understand what he's going through.
Right, but how many hours would you say that somebody has training? So if I apply for a job at your agency and I passed a background check and you're ready to assign me to a client, what's involved with my training? How much training do I get in hours? I know you do annually retraining, but
we do. We use a company called. It's probably about maybe 2 hours of training, but this training is not done at once, and we do training in between. We do the Alzheimer's training, not for everyone, but if someone is going to be working with a client that has the Alzheimer's dementia, the training that we give to them, we can give them the training in the office, or we can give them a DVD that we have with, and we can give them a test in addition to that. There are also other mandatory training. So it's anywhere from 2 to 6 hours of training, and this is done not just once a year.
okay. And my last question is, you don't assign anybody to a client that has dementia unless they've been trained in that. Is that correct?
Yes, we make sure that they have experience working with someone with dementia. These are questions that I would ask when, even in an interview, when I'm talking to someone, I ask, and we also give them a test to know what they know about working with a client with dementia, because quite honestly, a very large percent of these clients that we care for, they do have some form of dementia.
Right. Okay. Thank you. Thank you, Mr. Chairman.
Thank you.
Any no further questions? Thank you, Camille. Appreciate your testimony today. Clerk?
Up next is Meredith Donor.
Meredith, can you hear us? Meredith? Sam, they're in the room, right?
Yes, and she's unmuted. She you just can't see her video.
Meredith? All right, Sam, why don't we go to the next speaker? We can come back to Meredith when she's back online.
Okay. Up next is Chris Erb.
Good morning. I am going to be sitting in for Chris Herb today. He had to attend the funeral, so I'm Nikki Colley, not Chris Herb. So good morning to the General Law Committee. We are just here again to submit support and, well, we're in support of SB.
I'm sorry, who are you with, Nikki?
Yep, can you hear me?
Yep, I can, thank you.
Okay.
Let me just some logistical. So Sam, if you could move Meredith out of the room and she can email you.
Sure thing.
When she's ready. And then Nikki, you could just give us your full name again, Nikki, and who you represent. That would be great.
All right, so not Chris Herb, but I am his colleague, Nikki Colley, and I work for the Connecticut Energy Marketers Association, SEMA, and we are submitting testimony in support of SB 152, which that many of you are in support of, but I will just go and say that we represent 600 local family-owned energy companies here in Connecticut and employ over 13,000 people and provide approximately 450 million gallons of heating oil and propane to nearly half the homes. And we just want to thank Senator Haskell for introducing this bill and the committee leadership for allowing it to be heard. A lot of you co-signing it today. And we also want to recognize the Department of Consumer Protection for their work with the industry on this issue and their willingness to respond to the needs of the consumers in the industry. The bill and the suggested language that Chris attached in his written testimony will allow a customer to receive an electric delivery ticket if they choose to, and not a paper ticket. Again, you guys have heard over and over why. But again, this bill accomplishes several things, including modernizing the law to allow for heating fuel deliveries to electronically send confirmation, like most products and services, reduces diesel emissions by reducing the amount of time a fuel truck idles while the driver is printing a paper delivery ticket, which you guys also heard already, reduces the contact between the driver and consumers, protects them against criminals who might be tipped off they're not home and want to try to rob them, responds to consumers who do not want to deal with the paper tickets. So again, we attached our written testimony with additional language, and thank you for listening to this testimony. Any questions?
Yes, I think we do have one for you, Senator Wickos.
Thank you. And actually, this just this just dawned on me. Would you be okay if there was some language in the bill that provided that if you opted in for an electronic ticket, that it be delivered no later than 24 hours after the delivery of the fuel to your residence? Because if you have a driver dropping it off and giving a hard copy, it's immediate. You're getting it right then and there. And I can foresee an issue where, well, you know, we put all the information on an iPad, gets downloaded once a week. So now the consumer's getting it a week later. And, you know, I'd like to see if we had some protections for the consumer that says, you know, you'll receive an electronic, whatever it is, we'll call it a ticket, within 24 hours of your delivery. Would you guys be opposed to something like that?
We wouldn't be opposed to that. Honestly, I would refer back to my colleagues and we can, you know, work with the committee and DCP on getting that included in the bill, but I don't see that as being a problem.
Okay, thank you. Thank you, Mr. Chairman.
Yes, I was kind of assuming that this would be instantaneous on delivery, like it would with UPS or other times where you sign automatically and get it. So maybe that's a good thought. Nikki, just let us know what the technology is that has to go back to the main office and then be forwarded out. I think Senator Wickos' point is a good one, but if you're using more instantaneous technology, let us know that as well.
Thank you, will do. Thank you.
No further questions for you. Thank you for your testimony. Sam, were we able to get Ms. Donaher back online?
Making her panelists again to see if she is ready.
Hi, can you hear me?
I can, thank you, welcome.
Hi. Sorry, I apologize, I was having some technical difficulties. Good morning, thank you for the opportunity to speak. My name is Meredith Donaher. My family owns and operates a energy company in Westport, Galt Energy and Home Solutions. So I am speaking in regards to SB 152 concerning the electronic delivery tickets. I know you guys have heard from a couple people already in support of this, so I just want to reiterate a couple points that have been said. We're in support of SB 152 because it will allow customers to have more choice in how they can do business with us. For the past 5 to 10 years, our customers have been requesting electronic delivery tickets, as people have become accustomed to being paperless with every company that they do business with. So as we go forward, I think, giving our customers this option is going to be crucial in order to meet the consumers' expectations. I also think doing electronic delivery tickets is going to allow us to be more transparent, and this sort of goes off of the question that you just asked, Nikki. So the majority of our customers are not home when we make the delivery. So for them to be able to get the ticket in real time, while they're at work through email or as a text message, I think is beneficial for the consumer. And again, just gives people more options of how they want to do business with us. And then lastly, just mentioning COVID-19, we've seen a huge demand in people asking us for this over the last year for obvious reasons. They don't want to interact with our drivers, and they don't want to touch anything that's left at their home. So I think overall, this is going to be very beneficial for both the customer and myself and our company are in support. Thank you.
Perfect. Thank you very much. Appreciate that. And not seeing any questions for you. Thank you for your testimony.
Thank you.
Mr. Clerk.
Sorry. My bad. Up next is Cameron Champlin. Champlin. My bad. He's in now. Still muted. There we go.
We all set?
There, Cameron. Go ahead.
Thank you for the opportunity to testify today, everyone. I'm all set. I don't have to testify. Everything's been taken care of. Appreciate it.
Very efficiently done, Cammy. Thank you.
Sorry to waste your time.
Not at all. I'm sure we'll hear from you again. Thank you, Cam. Mr. Clerk, was he our last speaker?
He was our last speaker. Everyone else is good.
Terrific. Thank you, committee members. Appreciate your patience this morning and very efficiently done. We will have public hearings next week. Sam will send around the agendas if he's not already on Tuesday and Thursday. And then I would expect committee meetings probably the first week of March to try to start moving some bills out. So please stay tuned and keep your schedules open.
Thanks, everyone.
You're all set. Thank you, everybody. Thank you.
Thank you.
Thank you. Hey, Mr. Clerk, I still think you do an awesome job.
Thank you.
Hey, the only thing is there any way, when you do the speaker list, this may be asking too much, and if it is, tell me I'm asking too much.